For every contract to be valid, there are things that makes it a valid contract. It's just like for somebody to say he has successfully prepared a delicious egusi soup, jollof rice, or maybe any other kind of food. Jollof rice, for instance, has its own peculiar ingredients. You cannot make a jollof rice without at least introducing the tomatoes, the pepper, the maggi, the salt. All right. Rice itself is one of the substantive ingredients of making jollof rice, without which you cannot make jollof rice. The same thing is applicable when you come to talk about contract and its validity. There are things that makes contract a valid contract so that it can attract the force of law. And those are the things we're going to be talking about in this lecture series. So our topic for today will be the essential elements of a valid contract. Stricto sensu, there are about 4 different elements of a valid contract. This video is going to be looking at them. Number one of them all is offer. After offer, we have acceptance. After acceptance, you have consideration. The ones that follow is intention to create legal relationship. These are the 4 main cardinal essential elements of a valid contract, without which any contract cannot be said to be valid. However, the court in the case of Noah Ben Saka and Daniel Igor actually added the 5th, and if you like, the 6th elements of a valid contract, and they are capacity of parties and free consent. Once again, my name is Emperor Kemjika Nnaoma. I'm a legal practitioner and I'm a lecturer with Clifford University, Agri State. If this is your first time of coming across my channel, please do well to hit the subscribe button. And for you, the returning subscribers, thank you very much for sticking around. You are welcome to the Legal Playlist educational channel. In this channel, we teach everything that concerns law courses as it has to do with the Nigerian jurisdiction. So let us delve into the lecture for today. No need to define contract because we had actually taken care of that in our previous class. If you missed it out, look at the description section of this particular video and you will see introduction to law of contract, where you see the definition of contract law, the forms of contract, okay, running across bilateral, unilateral, express, implied contract, and every other thing that has to do with that particular class. But for today, let us begin with offer as one of the ground elements of a contract. That's what this lecture today is going to be talking about. Offer. And then we carry on other series, acceptance, and all of those. What is an offer? Offer, for me, in the ordinary sense, I want to say it means to give. When you give somebody something, it can be likened that you have offered the person that thing. To give somebody something means to offer the person something, to offer the person that thing. It's either you are giving a job, giving out a job. It's either you are giving somebody your time. It's either you are giving somebody your service. It's either you are giving somebody an opportunity. But whatever you give to somebody, in law, you have actually offered that thing to the person. So the reason why it looks as if the term offer is to an extent different from the term give, it's because legally speaking, in law, there are some things without people knowing when they do those things, they will be said to have offered something. They will be said to have made an offer. So, but just understand it generally that offer means to give, like in the simplest form. Then let us put it in a definitive form. Attempting to define an offer or what it means, we can say an offer is the willingness, offer is the readiness, offer is the voluntary preparedness of a party, always referred to as the offeror, which he communicates intentionally to another party, which the law will refer to as the offeree, of his action, so that when the offeree accepts what is offered, it can be binding on both the offeror and the offeree as a valid contract. So from this definition, we are quickly going to delve into the features of an offer. Don't forget, we say an offer is the willingness of a party intentionally communicated to another party, wherewith, if the other party accepts what has been communicated, a valid contract would have been said to come to being. So in this effect, let us look at the features of an offer. But before we look at the features of an offer, there are judicial authorities that back up this definition of an offer. You can look at the case of Benue Cement Nigeria Limited, I beg your pardon, Benue Cement Nigeria Limited, and Sky Inspection Nigeria Limited. Sky Inspection Company Nigeria Limited. So the case between Benue Cement and Sky Inspection is an authority to talk about what offer is. You can also look at the case of Damina and Akban. These cases, in a nutshell, gives life to the definition of offer. Of course, you can also look at the case of Orient Bank and Belante. Now, let us look at the features of offer. Of course, they are not far-fetched. From the definition of what offer is, you can deduce the features of offer. What are features? Features are characteristics. Features are the element of a thing. Features, you can say they are the qualities of a thing. So from the definition of offer, what are the features you can deduce? Number one is that there is willingness. That is to say, the party A making the offer, giving the thing, was not compelled, was not induced, was not manipulated. The person was not coerced. The person was not forced. The person was not under duress. The willingness, the voluntariness. So the thing must come willingly out of the person's own liking. It is the person's intention. So willingness is one of the features of an offer. The second thing to take out of that definition is communication. Every offer must be communicated to the person who it is made. Whether expressly communicated, of course, when you talk about expressly communicated, inside you have orally or, of course, by writing. Something when it is expressly communicated can either be communicated verbally by words of mouth or putting it down in writing. That one comes under express communication. Another feature of an offer, as you deduce there, is intention. The person making the offer must not have conceived it to be a joke. The person meant it. The person intended to make that offer to the second party. So that's why intention is one of the features of offer. The next thing you also look at it there is the enforceability aspect of an offer. The legal intention, all right? The legality of it, okay, of an offer. So the next thing you also want to look at there from that definition is clarity. When you are offering something to somebody, the law says the words, the way you communicate that thing to the person must be clear. The law does not deal with ambiguity. The law does not deal with vagueness. In fact, in the case of Benue Cement and Sky Inspection, the court held that an offer being made to another party must not be subject to a further interpretation. What it means is that when I communicate something to you, when I say I am giving you my house at number 27 Ikoyi, Lagos State, the words with which I communicated that thing I'm offering to you must be clear, so that you will not be looking for me to say, hey, sorry, what did you even say that time? No. An offer must come in plain language, capable of understanding by the person to whom it is made. These and many others can be likened as the features of an offer. I'd like to once more again plead with you to please subscribe to my YouTube channel. Don't fail to hit the subscribe button, and do well, of course, to share this content. Just click the share button and then share the content to as many friends as law students, lawyers, law aspirants to the bar in law school and all that. It will, of course, help them. You must be aware that an offer can be made expressly or impliedly. Like I said earlier, as one of the features of an offer. When you talk about offer being made expressly, it is to say, Mr. Arigbesola, please come to my office and take a check of 2 million naira for your performance as one of the staff of the company this year. That was a clear thing to say over the phone, orally. And then when Mr. Arigbesola comes to the office, maybe there are certain forms to be filled for documentation purposes. You see that that offer was also made in the nature, in the form of writing. So by express way to make an offer, it can either come orally or by writing. It is especially by writing when there are specific laws that say these offers must be made this way by writing. For instance, the Hire Purchase Act, all right, Section 2, Sub 2, Paragraph 9 is there. For instance, the Bankruptcy Act, you look at Section 18, Sub 1, and several other laws. For instance, the Conveyancing Law, the Property Act, as it affects different states, all right, can actually demand that an offer be made in writing depending on the subject matter of the transaction. An offer, of course, can be made impliedly, that is by conduct. But the law demands that where an offer is made by conduct, it must also be very clear for the person to whom it is made to understand that it is actually an offer. So that the person too can by conduct accept that the person has been made an offer. Another thing that looks like an offer, but it is not an offer. When an act amounts to an invitation to treat and when it amounts to an offer. What then is invitation to treat? That is our next subtopic under the essential elements of contract. An invitation to treat can be likened or is referred or can be defined as an intentional preliminary stage to a contract which calls for negotiation from an interested party upon which the other party to whom that offer is made cannot accept. So an invitation to treat is never an offer. Rather, an invitation to treat is the call for an offer. For instance, when you are walking on the road, you get to see a signpost written clearly, 2-bedroom flats to let, 1-bedroom flats to let, one self-contained to let, call within, and then there is a phone number attached. That signpost has not given you a house to occupy as a tenant or as a lessee. That signpost was merely telling you there is a house free to let. If you are interested, call this number. So in law, what that signpost is doing is directing, and that directing is referred to as invitation to treat. So to invite somebody to treat means to call somebody to transact. So if you are in need of the house and you call the phone number, you trace the location of the house to inspect the house, and you tell them, I am interested in this house. Upon you saying you are interested in this house, you have made an offer. And when the person, after negotiating with you, assesses you and allows you to say, okay, no problem, we can give you the house, that person had accepted your offer. So invitation to treat is not an offer. It is a thing of its own. It is a call for an offer to be made. Let us quickly delve into looking at some legally operational distinctions that can help us understand clearly when it is an offer and when it is an invitation to treat. By that I mean, are there ways that the law have been able to distinguish certain things, certain actions, certain circumstances clearly to say these ones are invitation to treat and they are not offer? For you to look at what is an offer and what is an invitation to treat, you can look at the case of Olaoba, the case of Oloba and Obafemi Awolowo University. The case of Oloba and Obafemi Awolowo University. It is an authority judicially to look at the difference between an invitation to treat and an offer. Let us now look at those operational distinguishing circumstances that the law will refer to them as offer. Number one of them is auction sales. Anything that has to do with auction sales, the beginning of an auction sales is an invitation to treat. It is never an offer. Number two is the display of goods on shelves. Is an invitation to treat, not an offer. Number three would be newspaper publication, magazines and catalogs. Those ones will qualify to be offer, to be invitation to treat. Number four, you can look at tenders. Those ones also qualify to be invitation to treat. And then you can also look at timetable ticket for buses or for trains, where in this area the law has not really been settled, but we would like to take them one after the other very quickly so we can round off these lectures for today. Let us look at auction sales. What actually is an auction sales and why does it qualify to be an offer? An auction sales is a public call to create awareness for the sales of certain goods and commodities. You see, it is a public call to create awareness for the sales of certain goods and commodities, if you like, at affordable rates. So when a call is made to say on the 27th day of August 2025 at Clifford University, EHA campus, Abia State, there is going to sell the farm produce from the agricultural faculty or department of Clifford University, message is sent across. By reason of that message, the law refers to that message that is sent across as an invitation. You are inviting members of the public to come and transact with Clifford University on the 25th of August 2025 at a certain time. So what it means is that any interested party can come to buy. When an interested party comes to buy, that coming to say, I want to buy, is making the offer. Now, how does it go? The auctioneer raises an item up to say, this one is going. Yes, who is pricing? And somebody price 15 naira. Say, yes, 15 naira going. Another person prices 200 naira. Another person prices 250. And if 250 is the highest price, is the highest bid for that particular item to be sold, you see the auctioneer will either hit the hammer or ring the bell to say that that price has gone to the person who had the highest bid. That is why auction sales is usually the highest bidder takes it off. And then there are laws that surround auction sales. All right. When goods are to be sold, there is something as reserved price. The auctioneer, who is usually an agent to the owner of the goods, who is the principal, must communicate the members of the public that so and so items number 1, 2, 3, 4, 5 have reserved prices. What it means is that, let's say if the reserve prices are 1 million naira, if nobody bids up to 1 million naira, that item cannot be sold. And if the auctioneer sells the item less than 1 million naira, the principal cannot be bound by that transaction. And so title will not pass to the purchaser. And if conversely too, the auctioneer fails to communicate that some items are reserved or some items have reserved prices, and a purchaser bids as the highest bidder and he fails to deliver the item, the goods, to the purchaser, the person has the right to sue. That is for want of warrant of disclosure or communication. So generally speaking, auction sales is actually an invitation to treat and not an offer itself. You can quickly look up the case of Harris, all right? The case of Harris rings bell as far as auction sales is concerned. Let us quickly delve into another area of the study today. We're going to be looking at display of goods in the shelf. And when we look at the display of goods in the shelf, there are two landmark cases I would like us to look into. The case of Pharmaceutical Society of Great Britain and Booth Camp Chemists. That is one case there. All right, a very landmark case. The law has it generally that anytime somebody walks into a mall, into a supermarket, into a shop, and you see goods displayed on shelves, even if it is not even a big shop where goods are displayed on shelves, maybe it's just a boutique where you see clothes on mannequin, right? Or people selling by the roadside drops their materials, their goods on the ground just to display. Generally speaking, anything that has to do with display of goods to be sold, the law refers to it. The law sees it. The law says it is invitation to trade because the person has not offered you that goods. If the person has offered you the goods, it means that as far as you touch it, you're going to pay for it. But it is invitation to trade, calling your attention to say, we are selling these goods. So it is when you come, you pick the one you want, and then you surrender it to the cashier, you surrender it to the sales agent to say, I want to buy these ones. And then the person can say, okay, these ones cost 2,000 naira, 5,000 naira, 20,000 as the case may be. By reason of saying, I want to buy these ones, you have made an offer. And when they say, okay, they calculate it and give you the price, the bill, that is a law seen as acceptance. All right. So when you see goods generally displayed, those goods are only calling your attention to come and buy them. And so in law, it is invitation to treat. You can also look at the case of Lockman and Sorry Economy. That's also another landmark case there to look at. There, when somebody walked into a supermarket and saw something that looked like a blood tonic, didn't know it was an explosive in a bottle, put it in her basket, and it exploded, the person sustained injury. The cause for determination before the court was whether or not the supermarket actually offered that thing to the customer and did not advise the customer accordingly that that was not a blood tonic she thought it was. But the court decided that it was not the supermarket that actually offered that thing to the customer. The customer actually picked it up herself. At all times, the item remained on the shelf. It was just merely an invitation to treat. Quickly, we're going to look at another form of invitation to treat. I talked about it earlier, tenders. When people who are into construction, whether road construction, project building construction, and all of those things. They call for people who can supply, who can deliver goods and services to them. They say, okay, please, if you can supply so and so thing materials for these our projects, give us your quotation. Tell us the minimum price you can supply those things. They either publish those things in newspaper, or they air them in the radio, they air them on televisions and all of those things. And so as much as people are interested, they will send in their quotation, breakdown of what they can supply and how much they can supply, and possibly why they are supplying at those rates. The law says that publication that was put up calling people to send their quotation is not an offer, it's an invitation to treat. It's merely calling interested parties. It's just like when universities will put up notices of employment. They say application is hereby required by suitably qualified candidates, and then they give you the criteria for the application and the drop email address where you will send your application with other accompanying documents, your CV and credentials. That information, that notice, that call for suitable applicants, to apply for the job is not an offer of the job. At best, it is actually an invitation to treat. So you who will now write your application seeking for that job, you are making an offer to the school, which of course, if the school accepts it, looking at your qualification, we now say, okay, you can work with us on so and so terms and all that. So it also qualifies to be an invitation to treat tender. The next and last one we're going to look at is what has to do with catalog, newspaper display, and advertisements. And this is another area that gives some people concern because of the issue, the landmark case in Khalil and Carbonic Smoke Board that has to border on unilateral contract. Every information, every notice displayed in the newspaper, generally speaking, is an invitation to treat, except otherwise is proven. And the cases to actually look at here will be the case of Gibson and Manchester City Council, and the case of Storey and Manchester City Council. In the case of Gibson and Manchester City Council, the Manchester City Council wrote Mr. Gibson, who was at that particular time a lessee, a tenant in one of its government properties, and intimated them of their intention to sell the property. And then Mr. Gibson also replied by way of letter to say, if you intend to sell the property, I am willing to buy. And that was the end of that negotiation. That was the end of that discussion until another government took over and carried on with selling the property again and did not continue with Mr. Gibson. Mr. Gibson raised an action in court, and the court held that that was only an invitation to treat. The letter was nothing more than an invitation to treat. Now you want to juxtapose that with the case of Storey and Manchester City Council, which was the next administration that took over the government. They wrote to Mr. Storey to say, we want to sell this property. If you intend to buy, please fill up the form attached to this letter. You will underscore one thing. Beyond the letter that was written to Mr. Storey in the second instance, an accompanying form was attached to it to say, if you are interested to buy, fill this form and we know that you want to buy because we want to sell. So in this case, the law interprets that case of Mr. Storey as an offer, because beyond the ordinary letter that was written, there was a document accompanying the letter to say, fill these things out and we know you're serious. So for Mr. Storey to have filled the form out means that he accepted the offer made by the Manchester City Council to sell their property. And the law looked at it and said, yes, this particular one is an offer. But the case of Gibson was a mere invitation to treat. So when you see things on newspaper, look at the case of Partridge and Crittenden. The case of Partridge and Crittenden is a clear indication of what an invitation to treat is also. Somebody had published, Mr. Partridge, the defendant had published in a newspaper to say, I sell quality birds, poultry birds. I sell quality ones at so price. He tagged prices to all the birds he was selling. And then the plaintiff bought the bird, all right? And how did he buy the bird? He sent 25 shillings to Mr. Patrick, the defendant. Of course, after giving him a call. And then somehow the defendant was sued, okay, for breach of the law that protected the birds. And the question for determination before the court was whether or not the defendant actually offered to sell maybe birds that were not up to the standard of quality of being sold. And the defendant said, I never made any offer. I never sold anything to anybody by way of offer. I only made a publication, and that was an invitation to treat. It was so and so person who made the offer. So you see, when things generally are put in magazines on advertisement, they amount to nothing but invitation to treat. So it was the person who made a call and made payment that actually made an offer. So to confirm the offer that was made by the plaintiff in the case of Patrick and Crittenden was sending the fowl to the plaintiff. So in this instance, it's actually a pure case of invitation to treat in the case of Patrick and Crittenden. And then, of course, finally, to distinguish the factor that makes the case of Khalil and Carbolic Smoke Ball to be an offer is beyond the fact that Khalil and Carbolic Smoke Ball Company said any person who takes this smoke ball by the way it is prescribed and still catches influenza, still catches flu, we will pay the person £1,000. It is not just that they attach monetary damages to it. They also made the statement that this £1,000 had been deposited in a bank account. So these things are further indication that they meant what they were saying. So the law interpreted that this is beyond invitation to treat. It is actually a clear case of an offer because they have made us to know that any person who does this, we are going to do this. And this is not just a mere promise. This thing we are going to give to you, it is in so bank account of ours. If you just oppose it with the case of Wicks and Tybard, you will see the clear difference between Kali and Kabali Smoke Ball case and the case of Wicks and Tybard, where a man had said, anybody who marries my daughter, I'm going to give you XYZ amount. And somebody married the person's daughter and the man never gave the money. The plaintiff sued and the man was like, that was a mere puff. It was just a gimmick to attract suitors to marry my daughter. And the court actually heard that that was an invitation to treat. So, make no mistake. Of course, invitation to treat is also fine, confusing sometimes in the case of electronic contract. But summarily, because we don't intend to extend this lecture beyond the time now. When you go to online shops, let's say, for instance, for the purposes of this lecture, I'll mention Konga, I'll mention CDCare, and several other online shops. The law has held severally that the display of goods to be sold on their portal is nothing more than invitation to treat. You will find a button where an option button where it is written order, where you can click and then place your order, or where you can click and then it will direct you to shop. That button, as far as you click it, the law says you have made an order. You have made an order. And how that your order can be accepted is when they provide you with a platform to make your payment and then deliver your goods. This is a clear cut-out case of invitation to treat. Gentlemen, this is where we will draw our class to a close today. Don't forget, this topic of today was actually on essential elements of a contract. And for this particular topic, we dealt with offer as one of the essential elements of a contract. Next class, we're going to be talking about acceptance, and then we will project to consideration, and then intention to create legal relation, and then we finally conclude the essential element of a valid contract with capacity of parties. Once again, I am begging you, do well to subscribe to my YouTube channel. As you subscribe, please turn on the notification bell for all so that you will always receive our lecture series anytime we drop one. I am Emperor Kenjika Nnoma, a lecturer with Clifford University. Clifford University is located at Isialangwa North, Abia State. I tell you the truth, is a school to be, is a school to go to, is a school to attend. It's actually a private university where law is taught to its zenith. And of course, we have nursing department, we have agri department, we have med lab department, and several other very beautiful departments. You want to attend Clifford University? Please give us a call, give us a check out, give us an evaluation, come down to our university, and I can assure you, you get maximum and optimum and nothing less than education in Clifford University.